3 things about depositions in Massachusetts. Good afternoon. I'm Neil Burns. I'm an attorney. My office here at 6 Beacon Street is where I've been practicing law since 1987. And along with my partner, Roshan Jain, we represent victims of personal injury and legal malpractice. And today I've been asked to talk about depositions. And I've narrowed it down to 3 things that you really need to know. Number 1, what is a deposition? Deposition in a civil case is when the opposing side or sides are allowed to ask you questions. They ask you questions you're under oath, and we hire a court reporter, and the court reporter types up everything that you say, and they ask you questions. Sometimes they go around all sorts of circuitous ways to find out different things about you, but basically they ask about your prior health and medical history, your prior work history, your current work history, and the accident and the injuries you sustained from the accident, or in a legal malpractice case, the damages you have from that case. And these depositions can go from an hour to multiple hours to multiple sessions, multiple days, but they tend to be 2 to 3 hours in a typical case. And that's what a deposition is. So it's oral questions that you answer with your attorney by your side. Historically, it was in the conference room of the opposing attorney. These days, it can be by Zoom, of course. Number 2, how do you prepare for your deposition? This is the key. This is the absolute key to your case. You need to work with your lawyer. You do not have a phone call. You do not read a document only. You must review all the evidence so far in your case, your answers to interrogatories, your production of documents, any admissions, any opposing sides' depositions, what they've already testified to, so you can see what's going on from their perspective, and you prepare with your lawyer. Different questions are prepared for. Again, prepare for where you worked before, where you work now, what your injuries were before, what your medical history was. These are all things they're going to get out. They're all things they're going to discover. So you need to get it out and into the open and let them discover it. It's never been a problem if you're open and honest. So the preparation is key. Sometimes we prepare for many, many hours, depending upon the nature of the case. And number 3, and this is the question that really folks want to know, is when does the case settle after a deposition? Sometimes it settles literally in the conference room. The attorney says, you know what, I've been authorized to extend an offer of such and such amount of money, or we were just holding back on offering the policy. Now we've got the policy for you because we see that your client showed up on time, was appropriate, was appropriately dressed, could make a good impression for a jury. So we're going to offer you the policy, we're going to offer you some sort of amount of money. Sometimes the attorney has to talk with the insurance adjuster afterwards. But sometimes after a deposition is a good time to discuss settlement or mediation or something like that. So a deposition is a key step in moving towards resolution. And if the case doesn't settle, if an offer is not made and mediation does not occur, we're now ready for trial. So it's key, because once you've had a deposition, they have to be able to say to a judge, yeah, we've done discovery, judge, and we're ready as well. Of course, we're always pushing the case towards trial because we can't resolve a case until the trial resolves or something settles beforehand. So if you have an attorney that's helping you towards a deposition, prepare. That's key. Do as much homework as possible, and then sit back and be ready for your deposition when it happens. If you have a question about a deposition, if you have a question about a case that may go to deposition, give us a call. 617-227-7423. Call Burns and Jain. Thank you.